I love these topics because one consistently rolls into the next, and now unless you got something else to add to that, I would like to pick up on our fourth topic, compliance with changing payroll obligations.
Sure.
All right. So, yeah, I had mentioned that each state is different, obviously. So, for the sake of this video, since you're a New York lawyer, we're going to speak about New York, unless you know anything about any other state. I know GCs are liable to sub payroll obligations, which is one of the subtopics that you spoke about prior to us getting onto this video. So, if you want to expand on that as well, and what contractors really need to understand about this payroll obligations.
Sure. So basically, the way I like to look at it is if a subcontractor is hiring a worker, the entire project is hiring that worker. So the subcontractor has first line obligations to pay the worker. The owners of the subcontractor have the obligation to pay that worker. If that worker isn't paid, everyone up the chain is liable, from the GC to if they're a sub to the ones who brought them on. So really, we're starting to see, and this is public and private. So we're starting to see a lot of our private GCs asking subcontractors for payroll records, for reporting records, to make sure every dollar is further accounted for, because ultimately, everyone can potentially be liable for not making payroll obligations. And that opens it up to punitive damages, liquidated damages. Lots of scary numbers come out to play when you don't pay workers.
So I got a question, and this kind of goes into this topic and one of the previous topics. If a subcontractor has to perform work and they don't have enough labor and they bring on a sub to themselves, right? What should they understand about that? Should they obviously they should have their own subcontract in place, right? Because if the sub brings on someone and they get hurt on the job, for example, or like how you're saying, when they bring on someone of their own payroll, I mean, how can you expand on something like that? For a sub to bring in their own sub.
Sure. So one of the biggest issues, number two, other than getting paid, getting Benjamin Franklin into your pocket, is indemnification. It's a scary word. It touches on insurance. It touches upon contracts. It touches upon injured workers. What we want to make sure, and when we work in consultation with the insurance providers, is, are we protected in the event of a labor law claim? Are we protected in the event that a worker gets hurt? Because New York is a little bit different than some other states, where if a worker gets hurt, they generally can't sue their employer because they have workers' compensation benefits. But the injured worker can sue the higher tier sub, the GC, and the owner. So we want to make sure, as that subcontractor who's bringing on the sub, that that subcontractor is protecting everyone up the chain. Because sometimes it's a house of cards. If one contractor doesn't have proper indemnity, everybody in the chain loses insurance coverage.
Wow.
And that can be a death knell, because now you have the GC, the owner, saying, why did I lose coverage on this claim? Because subcontractor, you brought on another sub who didn't have the right coverage and you didn't have the right contract. So you have to make sure that if you're a subcontractor or a GC or anyone bringing on labor, you have proper indemnifications, you have proper risk transfer, proper risk sharing, to make sure that you're not the one holding the bag if there's a workplace injury.
Such an important part, such an important answer, because I've been hearing more and more stories of people just bringing on subs to their, and the GCs aren't even aware of it because they don't know who's who, and they don't have contracts, they don't have anything.
Sure. And I know we spent a lot of time talking about the subcontractors. General contractors have to make sure that their risk and compliance departments are staffed up. We have in our contracts from GCs down that if a sub brings on a sub, we know about it right away, or they're not allowed on site. And that second tier sub has an obligation to maintain the insurance, same insurance requirements that the sub is required to keep. So if a sub has to have a $5 million policy, the sub has to have a $5 million policy. And we're counseling our clients to beef up compliance, to make sure that insurance is protected, that the risk transfer is as it should be. Otherwise, a project in the green will hit the red very fast.
Great. That's awesome points, man. I really appreciate that because, again, it's just a topic that I've been hearing more and more about. So,
And then, we're going to hit on contracts next. One of the strongest tools we like to put in our contracts, and again, every job is a little different, is what can the upstream contractor do if a claim like this happens? There's some provisions that say we can hold money back. A sub isn't getting paid until this lawsuit is resolved. And that could be a 6 or 7 figure sum. And what's the subcontractor going to say? Well, I'm entitled to this money because I did this work. And you're going to say, correct. But you also have a potential $1 million claim that you caused by not having proper insurances up the chain to protect everybody, to protect yourself, to protect us from your sub. So we always have to be mindful of that and finding ways to protect ourselves when things go wrong.